FinTech News was the first to publish the article titled Ripple versus SEC lawsuit could be concluded in 7 possible ways. The SEC's Ripple lawsuit has taken a turn for the worst, and there are now rumors that the case will be a drawn-out court struggle that will result in enormous fines. On the other hand, speculations over the results remain. One knowledgeable individual has demonstrated each of the 7 potential outcomes that could alter the current situation. There are 7 different scenarios in the Ripple case that you need to be aware of. I have considered 7 different scenarios that could unfold in the Ripple situation. The litigation is over after Ripple and the SEC negotiated a deal with Ripple, and the SEC agreed to the finding that Judge Torres has made about remedies. Neither one files. In the matter is now over 3 Ripple 6th of February 2024. An XRP enthusiast named Ashley Prosper, who had previously submitted a Freedom of Information Act FOIA request to the Securities and Exchange Commission detailing its correspondence with JP Morgan about Ripple and XRP, has detailed 7 potential outcomes that could occur in the Ripple lawsuit in the first place. Prosper mentioned that both parties could agree to a settlement, which would put an end to the protracted legal struggle. Even though there are no ongoing conversations regarding this matter, settlement discussions could take place at any time. Although it has been claimed that Ripple is willing to negotiate a resolution to the dispute, the CC has not demonstrated any interest in doing so. According to Prosper, the litigation can be resolved if both parties agree to the ruling that Judge Analyses Torres has issued about the treatment of the affected parties. Under these circumstances, no party would file an appeal against the judgments made by the judge, including any decisions on remedies in summary judgments. According to this scenario, the outcome might take place somewhere around the year 2020. A third possibility that was presented by Prosper is that after the remedies phase, either party or both parties could file an appeal with the Second Circuit Court of Appeals. The litigation may be resolved between the years 2025 and 2026 if the court agrees with the decision made by Judge Torres, and if neither side takes the matter to the Supreme Court. In addition, Prosper examines several other possible possibilities, such as appeals to higher courts, remains back to Judge Torres, and the chance that the case could be heard by the Supreme Court. Each scenario comes with its schedule, which might range anywhere from 2025 to 2028, depending on the various legal actions and the appeals process that are involved. As of right now, the action is at the remedies phase, which is the phase in which the proper remedy for the alleged violations of securities law committed by Ripple is being determined. Ripple had to submit financial documentation relating to its sales of XRP to institutional clients as a result of a recent order, which is just one indication of the arduous legal procedure that lies ahead. On the other hand, Ripple has requested an extension of 1 week to disclose all of the documents, but they have denied that this will cause the case to go on for longer. What comes next? John Denton, an attorney who advocates for XRP, has commented on the outcome of the case. We refer to the legal struggle between Ripple and SEC as scorched earth litigation, which implies that it will be a very difficult and drawn-out battle. In addition to highlighting the SEC's pursuit of hefty penalties following prolonged litigation, he emphasizes the possibility of Ripple becoming subject to sanctions. According to Denton, the fines might reach up to $100 billion, even though he had earlier stated that they would be anywhere between $10 and $20, $1 million. Despite initial hope, the complexity of the litigation indicates that it will be a lengthy battle. Bitcoin regulation and compliance may be impacted as a result. A regulatory clarification amicus brief will be submitted by Denton if an appeal is lodged rather than a claim for damages. Keep checking back for further developments. The blockchain company Ripple has submitted a court filing in the ongoing legal struggle between the Securities and Exchange Commission and Ripple. In the filing, the blockchain company requests a brief extension for the deadline linked to financial disclosure. In response, the Securities and Exchange Commission said demand for post-complaint contracts and financial statements over the previous 2 years. This action has been taken in response to the new development. Fred Rispoli, legal expert and champion for XRP, voiced his concerns about the ongoing legal processes and offered his opinion on risk analysis of the in response to the most recent turn of events in the ongoing dispute between the SEC and Ripple. Fred Rispoli utilized the social media platform X to express his thoughts in his tweet. He took the opportunity to voice his dissatisfaction with SX's continued involvement in the issue, expressing his hope that the agency would transfer. for its attention to something else. Ripple, on the other hand, said that there is a possibility that the SEC will give in after the final order on damages, which is expected to be issued around the middle of July. Despite this, he made a passing reference to the possibility that the case would be appealed, even though an order from the Second Circuit Court is not anticipated until the middle of 2026. An evaluation of Ripple's business strategy risk fully investigated Ripple's strategic activities, focusing specifically on the company's response to the request for discovery by the Securities and Exchange Commission. The decision that Ripple made to defend the discovery was called into question, and he said that the SEC might be able to take legal action against Ripple for post-complaint sales in the future if they hide the information. The relevance of the damages aspect of the case was emphasized by Ripple, who also brought attention to the SEC's investigation into Ripple's ongoing operations in the wake of the verdict on the motion for summary judgment. Messily continuing to restrict or eliminate Ripple's institutional business is the primary aim of the SEC. As stated by Ripple, he expected that the next briefing would provide an in-depth examination of Ripple's actual operations and how they deviate from the activities specified in the merger. The huge stakes that Ripple is facing in this legal struggle were brought to light by Ripple, who also emphasized the importance of strategic maneuvering to successfully navigate regulation obstacles. When the Securities and Exchange Commission bill filed lawsuits against a large number of organizations and accused alternative cryptocurrencies of being securities in 2023, the cryptocurrency industry was confronted with a tidal wave of legal issues. The investigation into the XRP coin has been going on for several years. Over 100 investigations were opened by the agency in the previous year, and they are making significant efforts to achieve a comparable number this year. It has now initiated action against a different corporation situated in the United States cryptocurrency case. Before, the SEC traded station Crypto, which is situated in Florida, was the subject of a statement that was released today by the Securities and Exchange Commission. This platform, according to the most recent share, was providing interest income in return for crypto staking, but it did not register with the SEC to service users in the United States. The investigation was opened because the company was providing services that were not registered, just like other cryptocurrency companies. It was decided that TradeStation would pay a fine of $1.05 million, which will ensure that the procedure will not be protracted. On June 30th, 2022, Tradition voluntarily halted offering and selling the interest feature to investors, as stated in the judgment made by the Securities and Exchange Commission. TradeStation made the announcement earlier this year that it intends to stop offering any products and services related to cryptocurrencies in the United States market by February 22nd, 2024.